Good morning, Labas Ritas. My name is Ben Sanderson. I am of counsel and the Global Practice Manager for International Arbitration at DLA Piper. It is really wonderful to join you today for what I am sure will be a stimulating and thought-provoking journey into the future of business disputes. Please let me start by taking this opportunity to thank very much the organizers, Trinity Eurex, for their kind invitation to deliver this keynote address. I have been to the beautiful city of Vilnius on a number of times, and I have had the honor of recently representing the Republic of Lithuania in an investment claim relating to Snoras Bank. I have many friends and colleagues in Lithuania, and I look forward to visiting you all there in the very near future. And indeed, speaking of the future brings us to the theme of this conference, which is entitled, Bring It On, Future. It is a bold title. It is defiant. It demands action. It embraces change. But lawyers, generally speaking, are not good with change. But the agenda for today's conference will invite you to engage with developments that are already with us and will shape our future. From tech and IT disputes to the growing demands of ESG imperatives, the landscape has already changed. The political landscape has also changed, and it has changed acutely for the worse. Russia's invasion of Ukraine and threats made to other neighboring states will shape the next decades. A session later today will look at settlement agreements and will refer to such contracts as peace agreements. Even when peace comes, and we all desperately hope that peace will come soon, Russia's aggression will leave its clear imprint on all our futures. Now, to inspire us on today's journey, I want you to have in mind the words of Mahatma Gandhi, who said, "The future depends on what we do in the present." And I want to use this keynote address to suggest to you 3 changes that are happening now in the present that will shape the future of disputes for the generation to come. My first thesis is that disputes, and in particular arbitrations, will become more efficient. And what do I mean by efficient? Well, I think we should always view this term from the client's perspective. Clients want processes that are effective, reliable, and predictable. They also want processes that are time and cost efficient. Arbitration is growing in popularity in Lithuania and regionally, but I think it is fair to say that it is still a relatively new market. Clients are slowly becoming more confident in the use of arbitration and recognize its attractiveness, particularly on issues such as confidentiality and the ease of cross-border enforcement. But the relative lack of development of arbitration in the Baltic region, compared, say, to London or Paris, should not be viewed as a disadvantage. Rather, it offers, in my view, a significant advantage to you. It enables you to leapfrog those practitioners in the traditional hubs of arbitration that are, at times, resistant to change. It empowers you to shape the arbitration world that you want for the future. Now, arbitration has its critics. The process is no longer cheap nor efficient. The process has evolved to resemble a court proceeding, or at least so the story goes. But having spoken with a number of prominent arbitrators, the message is clear. You, the users of arbitration, the clients, the parties, you need to be active participants in the process. Do not be passive bystanders. You need to define the process you want, and you need to take advantage of the flexibility the process offers. But as general counsel, you may be asking yourselves, how do I do that? And the answer comes from one leading arbitrator at a recent conference. The arbitrator told the audience of corporate counsel as follows. First, make sure you attend the first procedural hearing, at which the procedural timetable is debated and agreed. Make your voice heard. If you need a decision within 12 months, say so. If tools such as expedited procedure would be suitable, ask for them to be used. Second, take control of your external counsel. You know the dispute far better than they do, and you certainly understand the commercial context better than they do. Make the process quicker and more efficient by ensuring external counsel only focus on the key issues and avoid arguing every single point, no matter how lacking in merit. Third, continue to explore alternative means to settle the dispute, whether by mediation or otherwise, in parallel with the arbitration. This should not be taken as a sign of weakness. The message was clear. The responsibility for achieving efficiency is the joint responsibility of the tribunal, of external counsel, and of the parties. What we need to do is think radically, including embracing technology. Before COVID, 99% of practitioners would have told you that it would be impossible to hold a full hearing virtually. We now know that that is simply not the case. Now, we could get bogged down in a debate about the pros and cons of remote hearings. Of course, many of us miss the energy and the tension of the physical hearing room. And there may be cases where an in-person hearing still remains preferable for reasons specific to that case. But I would put it to you that at least half of all commercial disputes could easily and more efficiently be settled using solely virtual hearings. This was unthinkable little more than 2 years ago. The question is, what is there that is unthinkable today that will suddenly become the new norm 2 years on from now? This conference has been designed to help you answer that question. I will now turn to my second thesis regarding third-party funding, and that thesis is as follows. I predict that within 5 years, 1 in 3 high-value arbitrations will be commenced by claimants who are funded by a third party. In many countries, notably Australia, the UK, and the US, third-party funding is now entrenched in the disputes market. That wave will reach these shores, and I predict that litigation funding will increase exponentially in Lithuania and in the Baltic states in the next 12 months. But before we go into the detail, it may help to set out some basic principles and to dispel some myths about funding. Let me start with the key myth. Third-party funding is only used by claimants who otherwise do not have the money to bring a claim. That is simply wrong. Third-party funding is increasingly used by solvent companies, including multinational corporations, who are looking to monetize claims just as they would any other asset. But of course, I am talking today to a room, or rather a screen full of lawyers and general counsel. I really need to be having this conversation with your CFOs, with your CEOs, who are constantly squeezing your legal budgets. And the conversation really is quite simple. You have many claims against different parties, but your legal budget is limited. You therefore need to prioritize your legal spend and only pursue, say, half of possible claims you could bring. But instead of letting some of those claims fester, why not see them as assets? A third party will pay all the legal fees for bringing one of those claims in return for a proportion of the winnings. And what is better, if you lose the claim, you do not pay the third-party funder the legal fees it has paid on your behalf. Third-party funding is non-recourse funding. Now, have that conversation with a lawyer, and their immediate reaction is, why would I give up a share of the winnings? But have that conversation with a CFO or a CEO, and they will immediately see a potential to drive revenues at no cost and at no risk. Embracing third-party funding requires a fundamental mind shift, like the COVID-driven mind shift that required lawyers to embrace virtual hearings, a change which promoted efficiency and took us into the future. Third-party funding will fundamentally change how our corporate clients view their disputes. And taking a second myth, third-party funding is only used where the funded party has a weak case. Again, that simply could not be more incorrect. Third-party funders are sophisticated commercial enterprises, staffed up with teams of lawyers poached from the leading law firms. The mere fact that they have given an additional layer of scrutiny to the claim should in fact point to there being stronger rather than weaker merits. Turning now to the growth of third-party funding. The growth of third-party funding will, in my view, be driven in two ways. First, third-party funders will open branches or send representatives to your country to explain why funding is a good thing. And second, law firms such as my own DLA Piper have already started to establish their own funds in order to be able to offer clients a one-stop shop for legal services and litigation funding. And any residual concerns about third-party funding can easily be addressed. To name a couple of those here, questions of transparency for conflicts purposes have already been addressed in the recent arbitral rules of many institutions, which now require certain basic disclosures to be made, and that trend will continue. Also, some of the observers will question whether it is right that a third party should fund legal proceedings, but as a non-party to the dispute, that third party should not be liable for the adverse costs if the case is lost. Again, I predict that the trend that we have seen in some courts, notably in the courts of England and Wales, will be replicated in arbitration, and we will see more successful applications for security for costs being brought by defendants. And funders are already building adverse costs and associated insurance policies into their pricing models. The future is already laying in wait in this regard. So, irrespective of your view on third-party funding, whether you think it is a good thing or a bad thing, I put it to you that third-party funding will play a key part in the future of all disputes practices globally, including in Lithuania and in the Baltic states. And now for my third thesis regarding Russia. Before I set out my thesis, may I first express my shock and my horror at the continuing war inflicted on Ukraine and its people. I know that with Russia as a neighbor, you also feel this war acutely. You stand with the Ukrainians and you also wish for peace at the earliest opportunity. My thesis on Russia is this. The next 5 years will see an unprecedented number of claims against the Russian state and Russian entities relating to the immediate effects of the war and the secondary effects of sanctions. Of course, any consideration of redress against Russia must first focus on the Ukrainian people. That goes without saying. But looking more broadly, I have two observations. First, looking at international law claims, there will be a wave of claims brought against Russia under multilateral and bilateral investment treaties. In response to sanctions, Russia is taking unprecedented action against foreign assets in Russia. Russia has amended its law to allow expropriation and to allow court-appointed administrators to take control of the assets of foreign companies. This is likely to affect Lithuanian assets, as well as a raft of assets held by other foreign companies. Lithuania has a bilateral investment treaty with Russia. Estonia and Latvia do not. However, there may still be avenues for Estonians and Latvians to bring claims against Russia, depending on the specific investment structure. As I mentioned, recently I had the honor of representing the Republic of Lithuania in the defense of an investment claim brought by a Russian investor under the Lithuania-Russia BIT, incidentally a claim brought using third-party funding. But together with my co-counsel in Lithuania, we were delighted to prevail on behalf of the state. While that claim was not related in any way to the Russian invasion, the positive outcome from that experience is that the Lithuania-Russia BIT was tested and found to be a sound legal instrument capable of offering Lithuanian investors in Russia the protection they need. Second, commercial claims against Russian entities are now gathering pace. Contractual breaches, claims of force majeure and the like will continue to spiral as parties seek to protect their commercial positions. And circling back to my second thesis, third-party funding is likely to be a key driver behind many of these claims. The question that remains to be answered is one of enforcement. How will enforcement be affected against Russian assets? The New York Convention, of course, provides a neat solution in the world of arbitration. But what about assets that are subject to sanctions? How will they be dealt with? Will a special claims commission be established to deal with damage caused by the Russian state? Will the peace, when it eventually comes, provide a regime for reparations? Or will we simply enter into a new world order? And here we move from the legal world into the world of politics. And I draw a line under my abilities to predict the future there. But returning to today, your mandate, given in the title of today's conference, is to embrace the future. I have given you 3 of my predictions, and you will no doubt hear a number of others in the course of today's presentations. Returning to Gandhi's quote, the future depends on what we do in the present. So I urge any remaining skeptics in the room to engage deeply and thoughtfully today in the ideas presented to you, and to engage particularly in meaningful conversation with the in-house counsel who are joining us today, so that we can provide the very best advice and service to them in the future. I wish you a very successful conference, and thank you again for the kind invitation. Ačiū.